Yeah, sorry.
Hi, I'm Bill Kelly.
Hi, Bill. Gary Schmidt.
How are you?
Hi, Chris Kang.
Chris.
Hi, nice to
Hi,
meet you.
Carrie Severino.
Hi, Gary.
Oops.
Oops.
Is that me or you?
No, that's me. I don't have any pockets. It's a common problem with women's clothing.
Yes.
We don't want any excess anything.
Right.
You want to get them?
I know.
Okay.
I've been
It's not very bright. Oh, thank you.
very constructive for a long time.
Oh, thank you. Appreciate it.
Ready? All right, let's begin. So, everybody, thank you for coming. Unfortunately, we just had word that Senator Sass can't join us because of a vote that was scheduled on Capitol Hill for exactly right now. So I apologize for those of you who are coming to see him. We're all going to do our best personal mocking imitation of him to see who's most like him. But I apologize for that. So we're just going to go right ahead into the panel part of the talk. And Gary Schmidt, my colleague here at AEI, who was going to interview or conduct a roundtable with Senator Sass, is going to participate on the panel. So you have all the bios of the people on the web or outside. So I just thought I would briefly introduce them in terms of their relevance to Supreme Court nominations and throw out a few questions just to get conversation started, and then reserve a good amount of time for questions from all of you. To my right is Christopher Kang, who was the Deputy White House Counsel and had primary responsibility for judicial appointments. Before that, he worked for Senator Durbin. Yes, and we're happy to join us. With Bill Kelly, who's at Notre Dame, and he was a Deputy White House Counsel under President Bush. And before that, I think worked on one of the independent counsel investigations under Judge Starr, and clerked for Justice Scalia, whose seat Judge Gorsuch has been nominated to fill. And to his right is Carrie Severino, who is now with the Judicial Crisis Network. I don't know, I guess every year there's a judicial crisis of some kind somewhere, so there must be a network.
We're working on finishing the crisis.
And before that, she clerked for Justice Clarence Thomas and Judge David Santel of the DC Circuit. And then we had to have one non-lawyer to make fun of on the panel. So we have Gary Schmidt, my colleague here, who works on constitutional studies in addition to national security affairs and intelligence here at AEI. And he has a PhD and worked under the great Herbert Storing, who was the editor of the Anti-Federalist Papers at both Chicago and Virginia for his PhD. So I couldn't think of a better group of people to talk about many of the issues that are coming up. So why don't we start with the issue that's very much in the news today, which is will and should the Democrats filibuster the nomination of Judge Gorsuch to delay or prevent a vote? And if so, what should the Republicans in the majority do in response? So I start with Chris and just go down the line.
Sure. Should they filibuster? Yes. Next. In some seriousness, I think that there are a lot of different reasons why you're hearing Democrats suggest that a filibuster may be appropriate at this time. On the one hand, I think that a lot of Democratic senators are pointing to the historic treatment or mistreatment of Judge Merrick Garland when he was nominated to the Supreme Court. For the first time in history, a pending Supreme Court nominee was denied a hearing. And so I think a lot of Democratic senators view this as what's been called a stolen seat, some of them, and sort of would have strong concerns about anybody, frankly, other than Merrick Garland, filling this seat. While that, I think, is an understandable reaction for some, that's probably the minority view. I think a number of Democratic senators are looking to oppose this nomination and possibly filibuster this nomination based on Judge Gorsuch's record, based on his record as a judge for the last 10 years that they believe shows that he is outside of the mainstream. And they would argue that if they were successful in filibustering this nomination, then the appropriate response would be not for the Senate Republicans to change the rules and lower the threshold by which Judge Gorsuch could be confirmed, but rather for President Trump to withdraw the nomination and actually follow what the Constitution calls for. It calls for advice and consent, not just consent. And in this case, President Trump sought the advice of the Heritage Foundation and the Federalist Society, but not that of Senate Democrats. And if he's looking to find a nominee who can get 60 votes and be confirmed, then he should start there. He should consult meaningfully with Senate Democrats, put forward a more consensus nominee, and that nominee could be confirmed.
Well, I don't really venture an opinion as to whether they should filibuster Judge Gorsuch. I think the reasons why the Democrats in the Senate are tempted to do that and seem more and more inclined to do that are pretty clear, and they've just been very well stated. I think that obviously there are different sides to every bit of that story, and the story of the last 30 years of judicial nominations is a tit-for-tat, no, you did it story on both sides of the aisle, and we are at the point now where there isn't any even notion of deference to a president, well, at least a Republican president, when it comes to Supreme Court nominations. I think that's unfortunate, and it's contrary to our long traditions, at least most of the time. Obviously, I think it's clear that Judge Gorsuch is more than qualified. He's historically well qualified. He's exceptionally able. He has an exceptional temperament. He's a beautiful writer. His views are obviously and completely consistent with the mainstream of legal thinking in the United States. His record as a judge is far from extreme. And if they wouldn't confirm him or even give him a vote, much less confirm him, then it's obvious that they wouldn't confirm or give a vote to any nominee of President Trump, which really is what's going on. And as for the mistreatment of Judge Garland, who, of course, is a very distinguished judge and a fine person, that's what happens when you don't have agenda control in the last year of a presidential administration. It's that simple. And it would have been folly for the Republicans to confirm him, and it would have been unquestionably the case that the Democrats would have done the same thing had the situation been reversed. And I think even to suggest otherwise is probably not really serious. It's just politics. It's politics. You lose elections, you lose your majority, you lose your agenda control. That's what happens. Ask Peter Keisler, my friend and very distinguished former colleague, who was nominated to the DC Circuit by President Bush in 2006. In the 2006 elections, the control of the Senate switched to the Democrats, and Peter Keisler never got a hearing for 2 full years of President Bush's second term for the DC Circuit, and any fig leaf justification for that was based upon the workload of the court, not justifying filling that seat. But of course, as soon as the opportunity arose, the Democrats filled every seat on that court, and it's the least busy court in the history of Western law to this day. And so it really is just politics. It's just politics, folks, and everyone knows it, and people are saying what they need to as a matter of politics. But as I said, if you're not going to confirm Judge Gorsuch, you're not going to confirm really any Republican nominee.
So I have to agree. I think if you can't confirm someone who is as unanimously well qualified as I think the ABA has called him twice, as Neil Gorsuch, who has broad bipartisan support from people like Neil Katyal, former acting Solicitor General for Obama, among many other liberals. I think the chief non-bipartisan support he has is in the Senate. Obviously, it's very divided there. It's hard to imagine someone more mainstream when, of 10 years in the court, he has, in the case, 2,700 some cases he's heard, they've been unanimous upwards of 97, 98% of the time. Again, not exactly the record of someone who is outside the mainstream. He agrees with his democratically appointed colleagues in the bench a large percentage of the time. The hearings were really just a show of how we can cherry pick literally 2 or 3 cases out of a decade-long career on the bench and try to make arguments that we don't like the results he reached in these cases, and try to extrapolate from those and say, well, therefore there must be a pattern of ruling against, whatever you want to call employees, the little guy, various things. None of that holds up under any scrutiny. What is historic about this is not the idea that Judge Garland didn't get a hearing. There have been many Supreme Court nominees historically that didn't get hearings, because obviously it wasn't even a thing to have hearings for a long time. Even within the last 100 years, I think that has developed. Would be historic is the idea of using the filibuster to block a nominee from having an up or down vote that has clear majority support. That has never been done. The only filibuster that has blocked a Supreme Court justice was Abe Fortas. That's in 1968. It was a very different situation. There were a lot of ethical concerns about his nomination, and it was a bipartisan concern not wanting this to move forward. This is a very different thing. This is talking about a minority veto and requiring a supermajority vote for every Supreme Court nominee going forward. And if they were possible, I'm sure they would do it for every appellate nominee, because that's effectively what was begun in 2003 when Chuck Schumer led the charge to change this. So yes, we can go back and forth over who started it, but I would challenge anyone to find something before, say, the Bork confirmation process that really rivals that as a good starting point, and certainly something before the filibusters of the Bush era, to say this is where it got nasty, when you had people like Ruth Bader Ginsburg getting unanimously confirmed up until then, and then suddenly there was a blockade of judges that were, again, highly qualified. Think of, Peter Kaiser is a great example, but Miguel Estrada 7 times filibustered and explicitly commented that it was because of his race, and by some senators. That's egregious. So yes, this has been ratcheting up. I think it's unclear to me yet whether the Democrats are going to actually be able to mount a successful filibuster. Last time they attempted it for Justice Alito, they got 25 votes out of the 40 necessary. One of those, of course, was then President Obama. But there were also a lot of Democrats who were still relatively institutionally driven at that point. So he had 42 votes against him on the up or down vote, but he only had 25 votes against him on the filibuster. So there were clearly people who thought, this is not someone I can support, but I do think they deserve an up or down vote. And of course, recalling Justice Thomas's confirmation hearings, if a filibuster was a thing that anyone thought was something one would do for a Supreme Court nominee, goodness, they would have done it for Justice Thomas. He had 52 votes to confirm. I think, for whatever reason, it hadn't occurred to Joe Biden to use this tactic, but he used every other dirty trick in the book. So I think this is a true novelty. What would be returning the Senate to its historic practice would be eliminating the filibuster so that we actually do get an up or down vote for nominees. It's ironic to hear senators, some of whom were literally making the argument that it was unconstitutional not to have a hearing and an up or down vote, and using those words, less than a year ago, are now arguing that now anyone except for Judge Garland somehow needs to be filibustered ad nauseum, or anyone basically that a Republican would nominate, because I literally cannot imagine a single person that the president could nominate at this point that would not they would not mount a filibuster against if they will do it against someone as qualified and as mainstream as Neil Gorsuch.
Before we turn to Gary, I just want to point out Carrie's sporting the latest fashion accessory, a confirmed Gorsuch button. I've never seen one of these before.
Right.
I'm sure we're going to see it at the shelves at Urban Outfitters tomorrow. It looks just like the sort of things they sell. Gary.
Okay, I'll play the role of a non-lawyer and be a political scientist for 2 seconds, even though I've given up being a political scientist for many years. I was just struck by when you were talking about Senator Biden, or Vice President Biden, and when I worked in the Senate, I was the Democratic staff director on the Intelligence Committee, and Senator Biden at that time was a member of the committee, and personally, every time he asked a question, it seemed like a filibuster. I mean, it just went on and on and on. So anyway, one of the things I was struck by on the question of the filibuster is the politics of it was I noticed, again, former committee member when I was there was Senator Leahy, suggesting he might not, in fact, be in favor of Senator Schumer's idea for a filibuster. And that struck me as Senator Leahy wanting perhaps not to spend this coin on this particular nomination. And perhaps, if you think about it, it's the next seat on the Supreme Court that's going to be most crucial in terms of where the direction of the court might go. And as such, I think Senator Leahy's in the back of his head is thinking, do we really want to do the filibuster now for what will essentially be kind of a tied-up court, or do we wait for the more prescient moment when the court really direction could change fundamentally for years? So again, I don't know, but if I had to game the politics here, I wonder whether or not some Democrats are wondering whether this is the right time and the right person to try to filibuster, because they're going to lose, and then the next attempt is going to be, I think, more difficult politically to sell. One of the questions maybe I should get up and pretend like I'm talking to Senator Sass, but one of the questions I was going to ask him is, the filibuster is a long tradition in the Senate. It obviously is not part of the Constitution, but it's been around since the 1830s, not used that much, but nevertheless, it's been part of the view that somehow the Senate, the filibuster not only protects minority rights, the senators in the minority, but also is used to force kind of a consensus about major policy decisions or legislative decisions. And getting sort of at the point now where I think people are wondering whether or not we should be getting rid of the filibuster altogether. And a good conservative like Senator Sass, who has a sense of history, his PhDs in history, I was going to ask him what he thought about sort of removing this traditional function or this traditional way of behaving in the Senate. There are reasons for that filibuster, and again, there may be time of polarization. It's pointless to have it because you can't reach a consensus. But on the other hand, there's probably something to be lost when, in fact, you get rid of the filibuster for such decisions. And then a nerdy final footnote. Chris mentioned advise and consent meant advise and consent. As somebody who's actually looked through the constitutional musings of all the state constitutions during the colonial period and then right after the Revolution, where there were a lot of privy councils that had advise and consent responsibilities. The truth is, advise and consent just meant yes or no. So with that historical nerd point, I'll turn it back to John.
So Chris, before you might want to respond to some of these points some people made in response to you, but also what I wanted to ask is, if you were a Republican, not a Democrat, but if you were a Republican, aren't you glad that there's going to be a filibuster? Because wouldn't you rather it happen now, that the Republicans have to vote to get rid of it, rather than someone who might be filling the seat of a Justice Ginsburg or a Justice Kennedy in the next seat?
I don't know. I mean, I think if you're a Republican, you don't want there to be any filibuster, right? You want Judge Gorsuch to be confirmed 98-3, or that's not the right math, 96 to 3. But
it's a new constitutional amendment.
But I do think that is the question. Is sort of when does it make the most sense? And I think that there are some Republicans who hold this view that Kerry's articulated, that if Judge Gorsuch can't be confirmed, then no one can, and so this is the best possible scenario and outcome, and that may be true from that perspective. But I wanted to pick up on this notion that there's no deference to presidents' nominees, or at least Republican presidents. I think that when you have 90%, almost 90% of the Republican caucus vote against Elena Kagan's nomination to the Supreme Court, I think that this whole idea of deference to the president probably has gone out the window, right or wrong, and it has been long-standing now on both sides of the aisle. I don't know that anybody's hands are clean here, but when you think about whether or not this is unprecedented or not, Republicans insisted on a 60-vote threshold 12 times for President Obama's judicial nominees. Some of them were not sort of on the level, sort of more about calendaring, I'll admit, but they even set a 60-vote threshold for a district court judge from Rhode Island. So the notion that a district court judge in Rhode Island should have to pass a 60-vote threshold, but a Supreme Court nominee doesn't sort of pass muster, right? It is about politics. It's about the ratcheting up. It would be great if we could get back to a time where everybody was confirmed 100-0 or 96-3. But the idea now that this is only a partisan thing, that the lack of deference is only because it's President Trump, that he could never confirm anybody, I don't think that's true. I think that if President Trump went back and really did, so setting aside the actual history of advice and consent, which is fascinating, and I'll have to update my talking points in my head.
The notion, not clear Gary's right either.
So I'll take that.
Don't defer to Gary.
I'll take that on
Don't
faith.
defer
But
to
I will
Gary.
say that I worked in the White House, during the first 2 years of the Obama administration as well, when President Obama nominated Justice Sotomayor and Kagan, and I saw what he did in practice when it came to advice and consent. The number of Republican and Democratic senators that he talked to before making those decisions. I saw him work across the aisle throughout to try to find nominees who would find bipartisan support. His very first nominee was David Hamilton. He reached out to the most senior member of the Republican caucus, Senator Lugar, to find a nominee that Senator Lugar would agree to support. And what happened? The nominee was filibustered. He was subject to a 60-vote threshold. Now, at the time, there were 60 Democratic senators, 59 Democratic senators, so it was a little easier for Judge Hamilton to be confirmed. But this idea, again, that this is so unprecedented for Democrats to be so unfair to President Trump, to request a 60-vote threshold, I just think that the history doesn't bear it out. Now, we can get into a debate and whether or not it's a productive one about who started the unfair treatment first or whose treatment is worse, but I do think that it's fair to say this is the result of the trend we've been on, and that both sides have been at fault, even if we disagree on how equally that fault might be.
Several things. One is the first time in the history of the Republic a lower court nominee had ever been filibustered was in 2003. Ever. And 10 of George Bush's Court of Appeals nominees were successfully filibustered by the Democrats in the Senate. That genuinely was unprecedented and a massive escalation. I remember at the time talking to Miguel Estrada after he got out of committee, after he got to the floor. And I said, well, smooth sailing. And he said, no, they're going to filibuster. And I said, well, silly me. I said, that's impossible. That's never happened before, ever. I can't imagine they would go to that level. And you see how silly, really naive I was, because it was all out war from that point forward. That was huge, actually, and that was unprecedented. And it is true that the Republicans did invoke cloture many times during the Obama administration, not successfully as many times as the Democrats had in the Bush administration. And I gave a speech in November of 2008 after the election saying that I hoped that wouldn't happen for the good of the institutions, but it was inevitable that it would, because you can't have unilateral disarmament. You can't have unilateral surrender. You can't play by different rules. And so what happened? The Republicans did make it very difficult to get judges confirmed. And what happened then? The Democrats changed the rules and to a majority vote for everybody but Supreme Court justices. And the result of that was it made it much easier for them, but in turn, it makes it much easier now for a Republican president. And the idea that there's something sacrosanct about the Supreme Court that just makes it different for filibuster purposes, I think is a make weight. The Republicans, I don't think, can tolerate this seat not being filled by whatever measure is required within the rules. And that's unfortunate, but I think that's the reality. On consultation, just a quick point about that. I'm pretty sure, actually, I'm not positive about this, but I've been told this, that the administration did reach out before making a nomination to many, many senators, including many Democratic senators. Now, the president had provided a list of 21 names from which he would choose, and so if a Democratic senator didn't like that list, then it wasn't open to add or subtract from that list. But I do believe there was consultation, and there certainly was in the Bush administration, lots of consultation. I think every Democrat in the Senate was called by somebody in the White House about the Supreme Court openings during those years. And finally, the first slate of Bush nominees in 2001 was announced, I believe it was May 10, 2001. There was an event at the White House, and there were 10 Court of Appeals nominees announced, 2 of whom, 20%, were failed Clinton nominees, Democrats, whom the president chose to put forward to give 20% of his first nominees to the other side of the aisle as a gesture, as a peace gesture. And that year, the Democrats arrived upon a strategy of filibustering, and they executed that, and the rest, as we see, is and is becoming more history.
Karen, you're in the trenches right now. Do you think that the filibuster will succeed or fail, and will the Republicans exercise the nuclear option, as it were? The nuclear option refers to the idea that the Republican majority will vote to eliminate the filibuster entirely for Supreme Court nominees, as it has been for the others. When Gary's on a panel, he hears nuclear option, he gets very excited because he's thinking about ICBMs on their way to North Korea. But
Nothing
that's
quite
not
that
what we're
dramatic.
talking
I
about.
hope excited is the wrong word.
Right.
No, with Gary, it's excited. No.
Ready to
So,
go.
Gary,
There are shorter range weapons too.
So yeah, I do think, first of all, JCN is actually probably the only organization in town that has advocated against the judicial filibuster through both Republican and Democrat administrations. So I was actually kind of cheering Harry Reid on when they got rid of that filibuster, because I don't think it is appropriate to have the level of partisanship that's developed in the judicial battles now. We would have been for it when the Republicans did it. The Republicans, I think, in all of these things, we've seen that maybe it took them a decade or so longer to catch up to what the current tactics were. So, it's like they keep on bringing a knife to a gunfight and then a gun to a nuclear arsenal fight or something. But so because they talked about doing it, that we were calling it the constitutional option, because it's about the constitutional right of the Senate to set its own rules. But whatever you want to call it, the Republicans didn't want to go there, or at least there were 7 of them that didn't, and they created the Gang of 14, and they blocked that. Some of whom are still in the Senate now. The Democrats took it one step farther. So, and when it came to the Democrats start filibustering appellate nominees, and then including a Supreme Court nominee, did Elena Kagan and Sonia Sotomayor get filibustered? No, they didn't quite take it that far. So each time, I think it's taken them kind of one term to catch up to where we are. I do think, though, that now that Harry Reid has done this, the cat's out of the bag, the genie's out of the bottle, the horse is out of the barn. It's not at this point to suggest that the Supreme Court filibuster is even a thing that deserves to be preserved. Maybe because people imagine that both sides of the aisle will get a chance to use it at some point, is very naive. The Democrats, in the heady days when they thought Hillary Clinton was a shoo-in for the next presidency, you had people like Harry Reid, like Senator Kaine saying, oh no, if the Republicans, and Senator Schumer left this door open as well, if the Republicans start filibustering her nominees, we'll just get rid of it. Harry Reid said it's going to be gone like that, and he snapped his fingers. And I have no doubt that would be the case, because that's about how long it took them when there was pushback on the Democrat nominees. Nowhere near the hemming and hawing that the Republicans took about whether or not they should eliminate this filibuster. They left the Supreme Court one in place, but again, it's not. If the Democrats had an opportunity, they clearly would eliminate this. So this is like Weekend at Bernie's with the filibuster, pretending that this thing really exists. We know it's only going to apply to at most one party. It will only apply to Republican nominees, and that's only if the Republicans decide to let it apply to them. So I think that would amount to unilateral disarmament, as Bill had mentioned.
I mean, are there any Republicans who might actually vote not to exercise the nuclear option? There's some senators.
Right.
Well, the majority over time have defended the filibuster.
Right. Well, some of them have already been explicit in advocating eliminating it in this context, like Senator Graham, for example, who was very opposed to it before, but he, I think, feels like it's gotten, and frankly, I think almost none of them are excited about the idea. If they were excited about the idea, you would have had them get rid of it all. You don't have to, wait around until they could have tried to change the rules earlier. I don't think you could have. You have a group of people that want to change them. That said, I think everyone realizes that it's not feasible to have a 60-vote threshold for Republican nominees and a 51-vote threshold for Democratic nominees. Just won't happen. I did want to comment on one point that Gary had made, which is the long tradition of the filibuster. And I agree that for the legislative filibuster, there is a very long tradition of using it to gain consensus on legislative issues. I don't think that the executive filibuster and the judicial filibuster has no impact on that, really. There are different calendars in the Senate, and they have very different pedigrees. The judicial filibuster is really sort of, it wasn't put in there thinking, oh, this is a way to gain consensus nominees. It was really just because of the way the rules were changed, it happened to encompass that calendar as well. It's not something that has been used historically, so it's really more of a novelty that it's even being used at all, whereas the legislative filibuster has a long, long history. I don't think you would ever get, I guess there's some people who are talking about it, but I just don't see there being interest amongst the senators in getting rid of the legislative filibuster, partly because that one actually still does function. It functions on both sides. Both parties appreciate it as a tool of making sure the minority has a voice in the Senate, and I think that's totally appropriate. it's different in the judicial context. And I think here the biggest thing is the fact that it's already effectively dead for Democratic nominees. So it's foolish to suggest that it should be applied to one party only.
So why don't we switch, unless Gary, you have any comments to make about the filibuster since you started all this. So why don't we turn to the merits of Judge Gorsuch, which Chris also raised, is let me ask, did we learn anything from the hearings about Judge Gorsuch? He spent a lot of time not answering questions, which is always a good strategy when you appear before the Senate anyway. But this was very frustrating to Democratic senators, but it might have been frustrating to the American people because I think they didn't get a great sense perhaps of what they think he would do or not do as a justice. So did we learn anything from the hearings? And a subsidiary question to that is he really a judge in the mold of Judge Bork, who was an AEI fellow for many years, or Justice Scalia, or is he actually a very different kind of judge? So, Gary, do you want to start?
Yeah, but I also just remind Justice Scalia actually was also a scholar here at AEI. He founded a magazine called Regulation, which we'll maybe get into a little bit later because I think one of the issues that's obviously very important on the agenda is Judge Gorsuch's opinion about the Chevron doctrine. So, but again, that's take us somewhere else. No, I actually, again, one of the questions I was going to ask the senator was, as somebody here who not only does constitutional issues and national security, I'm kind of bipolar, but the other part of this program I run, we do a lot of work on civic education, and I know more than likely there's hundreds of, if not more than that, high school civics teachers and government teachers who are told their students in their AP courses or whatever that they had to pay attention to the confirmation process and they had to come back and report on what they had learned. And I think what they would have learned is, the court, the decisions about court nominees now is so politicized that it's all about politics. It's not about the Constitution. And B, that the way to sort of get through your nomination is by not talking about such substantive issues. And so the lesson that, there may be a good reason why, in fact, judges were never appeared before Senate in person until I think the 1940s. Maybe they knew better that if they actually didn't have these kinds of examinations that the politics of Supreme Court decisions, the politics of appointments you may not have changed how judges would have behaved, but the lesson about what the court's supposed to do might have been seen as different. So on that sort of somber note.
Gary, Bill?
I actually disagree a little bit. I think there were many points that were very good civics lessons. In particular, he had some exchanges with Senator Sass, Senator Lee, and Senator Cruz about the role of a judge as distinct from, say, the role of a legislator, and the importance of a judge not looking to just the results in a case. There were a lot of criticisms of, well, I didn't like this case because this poor guy got stuck in a freezing truck in the snow, and that just seems really bad. Not here's what the law said, and you did something different than what the law said, because I think anyone who actually reads the law can see in that case that the word operate and the word refuse to operate are actually opposites, and you can't make one mean the other. That was the crux of that case legally. But everyone can identify with, oh my gosh, this poor guy is stuck in the snow and he's losing feeling in his legs, and this is a horrible situation. I would say, in that case, blame the legislator, blame the regulator, blame the employer. Don't blame the judge, whose job is to simply apply the law. So those were some useful lessons. I think we saw a lot of him not answering questions, partly because the senators were intentionally asking questions they knew he couldn't answer in order to help bolster this particular case. We've known for a long time that judges, particularly since Justice Ginsburg, but really even before that, there is an ethical standard that judges have to abide by in terms of not committing, not telegraphing how they would rule in a particular case. Obviously, you could talk about the principles of how they would view the law, and he did talk about that in terms of looking, to the text of the law, et cetera. But you can't say, I'm going to rule this way in a case. There's a lot of reasons. I mean, even you can look at it and say, wow, I think I know what I think about, say, Roe versus Wade. But when you've got the most intelligent lawyers in the country making arguments and thousands of pages of briefing on both sides, actually you might find out there's more to one perspective or other than you thought. I think the other reason is if you start committing yourself on cases, you're also going to get people understandably filing like recusal motions. If he got up there and said, wow, I think this is the worst case ever about any case, be it Roe, Citizens United, Heller, I don't know, you understandably have parties getting up there and saying, hey, can you recuse yourself when you're hearing this case? Because I don't want, you've already put a thumb on the scales. And we've had situations like that with Justice Scalia, for example, when he was giving a speech, mentioned his thoughts on the Pledge of Allegiance cases that were working their way up, and then he had to recuse himself, or he chose to recuse himself. I don't think he was forced to in that case. At one level, you can't really be forced to at the Supreme Court level anyway, but he wasn't even requested to, I think he did so voluntarily. The point is, those are boundaries that judges have to follow. And even aside from the fact that obviously we all knew that everyone's sitting there in a political way trying to get him to say whatever he wanted. I don't think that at the end of the day, that's actually the reason he didn't answer the questions, because can anyone imagine an answer to a question he would have given that would have won him, say, Barbara Feinstein's, Senator Feinstein's vote? Nothing. He could have gotten up there and said, Justice Ginsburg is my hero, and Roe versus Wade is my favorite decision ever, and I want Citizens United to die a painful, slow death. And they would have filibustered him. I mean, so they would have just said, oh, he's lying. We don't believe this guy. So it doesn't matter. Answering those questions would not have gained him votes. He's not trying to hide something by not answering them. He's simply trying to follow the ethical limits that have been set by every previous judge that's on the court right now. So Ginsburg refused to answer upwards of 70 questions. It's just not surprising that he's not going to answer them. The answer, I think, might be, instead of having 20 hours of hearings, let's go back at most to maybe the hour and a half that his mentor, Justice White, sat on the court. Then you can ask all these questions that he's not allowed to answer maybe once instead of 10 times each. Or you can ask some of the questions that are more relevant and not, and also a whole series of questions that I think should have been irrelevant about, complaining about, for example, the state of arbitration law, or complaining about how this or that different law was written. And on several occasions, he would say, you know what, Senator, you are welcome to amend that law and change it, and I will apply the new law. But you can't blame the judge for the fact that a law is written in a way that you don't like. And there were so many, whether it's RFRA or antitrust law or arbitration, there's so many different issues that came up that at the end of the day you just want to go, the Individuals with Disabilities Education Act, all of these different ones, you're going, you know what, you guys can clarify this. If you don't like how the courts have interpreted your law, have at it. But they'd rather take the shortcut of bullying a judge into doing so. I don't know.
Chris?
Oh, sure.
Sorry, I gave you one.
No. Yeah, it turns out I've got a lot I had to start jotting down little notes so I could keep track. So I think that there's been a lot of commentary about whether or not Judge Gorsuch has sort of answered fewer questions or answered in a less fulsome way than other nominees. I think there's probably something to that, although I think that Carrie may be right. Some of that may be actually, if we're being honest, some of that may be the politics that drives into this. But I don't know that it's necessarily unfair to ask what his views of the law are in certain ways. I think that, for example, if there's a profile of Judge Gorsuch in the Washington Post, and it talked about how the Heritage Foundation and Federalist Society made their list and how they screened them, and there's this sort of striking example of the Heritage Foundation had concerns about the church that Judge Gorsuch attended, and it took them some time to work through that until they decided that they were no longer concerned. I'm not sure, and I can't even imagine what basis there would be for concerns regarding what church the judge went to. We assume that a judge would set aside any personal views he might have in being a judge, but if the Heritage Foundation can look into somebody's church to decide whether or not he'd be suitable to serve on the court, I don't think it's unfair for Democratic senators to look into his actual rulings, to ask him about these cases. Kerry says anybody can look at the law in the Alphonse Madden case and come up with this determination about operate versus not operate. Actually, the concern is that Judge Gorsuch is the only judge who looked at it this way. The administrative judges, the other two judges on the 10th Circuit, found the other way. And this idea that anybody could sympathize with him, when he was asked, when Senator Franken said, what would you have done? He sort of sat there. He's like, I don't know. I hadn't thought about it. He hadn't put himself in those shoes to think about the real world impact. because the law is not just the law in black and white. You have to think about the impact that it has as well. And I think that, the other thing I thought about that was striking, there were two examples that I thought were striking in terms of how far he could rule. If we assume that there's this rule that you can't talk about pending cases or even prior cases, I'm not even sure about that, by the way, in terms of recusal. When you have a Supreme Court judge who has ruled on a case in the past, that presumably does not prevent them from hearing a similar case in the future because they've already given their view on the law then. But there were two things that struck me in terms of Judge Gorsuch's refusal to answer questions. One was around the response to President Trump's denigration of the judiciary and sort of his tweets about a so-called judge and that judges would be responsible if there was a terrorist attack. And Judge Gorsuch sort of pointedly would not condemn those remarks specifically from President Trump. And I'm not sure what the legal case would be that he would have to hear regarding the appropriateness, whether or not those remarks were appropriate. Now, he said anyone is anyone, and he clearly felt that that was as far as he could go, but that didn't really ring true to me. The other question that Senator Whitehouse asked was actually around the funding of the Judicial Crisis Network, and he asked Judge Gorsuch, well, would you ask them to explain where their funding comes from? Who are the people who have put in $7 million to block Judge Garland from having a hearing and $10 million to support Judge Gorsuch? And he said, no, I won't ask them. I'm not sure what the legal principle is for why he couldn't just ask. Though it's up to you whether or not you disclose, up to your funders. But I also thought that what was interesting about that is that Senator Whitehouse raised the recusal question in that context. If you don't know who's funding this campaign on your behalf, how do you know whether or not to recuse yourself? I thought that those were interesting questions that don't necessarily fall within the usual construct of I can't comment on a case or controversy, that I thought that he could have done more, he could have said more, and maybe given some senators more comfort. Would he have convinced every Democratic senator? No, but I think that if he'd been able to give a little bit more, it is a political process, he might have been more likely to get 8 Democratic votes on cloture than he is today.
Gary had his.
Well, go ahead. I'll after.
Bill?
I think that actually the hearings were, I agree with Carrie on this point pretty strongly, that it was actually a pretty good civics lesson about the role of a judge and how a judge ought to behave. I thought that Judge Gorsuch spoke really powerfully and well about how a judge should go about deciding cases. And unfortunately, he had to do that a lot because there were 2 long days of hearings. But I think that was really very important. And the idea that he is supposed to talk about the substance of cases and his views about the law is, it's contrary to long practice. It's politically foolish to even consider doing that. And much more importantly, it's really injudicious to, in the role of a judge, prejudge a case. The truth is, and Judge Gorsuch said this, and I think he meant it, I'm sure he meant it, and I think it's true, that if you are a good judge, even if you think you know how you would rule on a legal question, you can't know that until you have a real case with real facts, with real briefs, with real lawyers and real colleagues, and real deliberation, a real record, where you have to think about that. And you have to decide each case anew and on its own. And so it's not just that it would be wrong and imprudent to say, well, I think that Citizens United should be overruled. It would be contrary to the judicial role because if you're a good judge, you shouldn't know how you would rule on that, in fact, when the time comes. Now, you might have strong inclinations, obviously, but your mind as a judge should be open. And I think that he communicated that very effectively through the hearings. And I think that actually is an excellent civics lesson about the judicial role. Indeed, maybe the central civics lesson that people ought to hear about the judicial role, that it's about the case and not the politics of the outcome, the politics of the outcome, the outcome, the outcome, the outcome. It must be fantastic, by the way, to be a Democratic nominee because your judicial philosophy is that the law requires a result in virtually every case that I like. It's true. It's true. think about that. How many times have Justice Kagan and Justice Sotomayor ruled in big cases that matter in ways that they didn't like? I'll bet very, very few. And they're not being dishonest. They're not being willful. I think they're both fair-minded judges. I have great admiration. And I went to law school with Justice Kagan. I've known her for 30 years, and she's a superb person, a great lawyer, and I think deeply, deeply honest. Her judicial philosophy leads her to outcomes that she tends to like. Not always, but she tends to like. It's only the Republican-appointed judges, apparently, that have judicial philosophies that constrain them. Now, do they always live up to that? Do they sometimes reach outcomes that are inconsistent with their stated methodologies? Probably. Do they do so dishonestly? I doubt it. Is it possible? Sure. But at least there is some constraining judicial methodological commitment that Judge Gorsuch brings to the table when he comes to cases, instead of, I'm just going to look and see what makes sense. And that's very powerful. I actually think that in many ways the future of the Republic depends upon maintaining that difference between what the law is and what we would like to have as politics. That's the fundamental distinction of US government, actually. And so, do I think it was a waste? No, I don't. I think that civics lesson came through loudly and clearly. And as for individual cases, you know, could he have ruled differently in some cases than others? I suppose so. I don't know. Does it show him to be a heartless monster that, you know, the outcome of one case was personally unattractive? Please, I don't think so at all.
I don't know that anybody's saying that either.
Well, that's the
right?
implication, that he's not viewing this as a human problem.
It's about looking at how his judicial philosophy gets to that result.
Yeah,
it's not saying that he's a heartless person.
Well, but his judicial philosophy leads to outcomes, whatever they are, without fear or favor. That's the oath, right? And it might well be that there are you know, hard consequences for people from cases. There's a lot of cases. It's a lot of cases. And the one thing about Judge Gorsuch, I want to say actually, that is clear, is that he's a fantastic person. Have you ever heard anybody say a bad thing about Neil Gorsuch? Very, very rarely, and not credibly. He's a fantastic person. And believe me, they've looked. They've looked, I promise. That matters a lot. He's a fantastic human being who's a thoroughly decent person. And so do I think that Judge Gorsuch doesn't care if the human consequences of a case are unattractive? I don't think that, actually. Do I think that he, in reasoning, engaging in the legal reasoning that leads to an outcome is insensitive to that? I doubt it, actually. I doubt it. I don't know. You know, I'm not in the chambers. But he's really a lovely person. And that actually, to me, it kind of matters, actually, that we have people of that kind of character and deportment discharging this kind of office. I feel the same about Justice Kagan, for example. She's a phenomenal person. And you will not hear, you know, people criticizing, you know, her behavior, her attitude, the way she treats people and the like. And her attitude toward human beings, like Judge Gorsuch's, I think is quite humanistic and quite humane.
Let's take one more comment, then we'll turn to questions.
Okay. I'll concede to Carrie and Bill that you know, that some of the exchanges perhaps were good civic lessons, the role of judge and the like. But to get back to, I think, what John was trying to get to, it didn't go very far. I mean, there's a distinction there's ground between, you know, somebody who's only looking to get how the judge is going to decide as a policy matter versus the role of the judge. I mean, there never was much depth of analysis of what kind of originalist is he. You know, I mean, I mean, Justice Scalia is one kind of originalist, and the grounds for being an originalist are different from perhaps Judge Gorsuch. And I suspect actually he's much more in tune with Justice Thomas about natural law and natural right than perhaps, you know, Judge Bork or Justice Scalia were. So there was a lack of depth of questioning on that front that I think would have been also useful to get to. And you know, so I take your point that, you know, sort of for a high school civics lesson, maybe it was satisfactory, but as far as getting more understanding of how his own judicial philosophy, or what his judicial philosophy was. I don't think the hearings actually got very far.
So before I turn to question, I can't resist commenting that to me, he seems like he could well be a conservative activist of the kind that would have driven Judge Bork, Judge Bork crazy. This is a guy who wants to get rid of the Chevron doctrine, which would allow judges to second guess and replace their judgment for those of the administrators who are making regulations. And I would have thought there'd be a lot more questioning about his work with John Finnis, the great natural law theorist, and his book about euthanasia, where, I don't know, he seems to me to quite clearly be a fan of natural law theory, which is what the Bork-Scalia approach to judging, and not just Republican, but Democrats spent decades trying to get out of constitutional law. So anyway, that's my thought. Any questions, comments? Unlike me, make sure it's a question and keep it short. And yes, right here in front. Anybody who's been subjected to the confirmation process, we'd love to hear from you too, and your own person. Oh, Judge Williams, I'd love to hear. Why don't you ask first, second question, okay, after young lady right here.
Thanks for your presentation. But I just wonder if we can change the word politics to the justice, that will change the whole thing. So maybe we have to consider legal reform. And currently we are talking about filibuster or something like that. So I just wonder if that is because the politics, they were influenced by the establishment or influenced by the lobbyists. So if we are thinking about working for the voters, no matter you like it or positive or negative answer, you are supposed to give your answer and allow the Senate to give you a vote, see how many votes is for you, then you got passed or not. So if by this reasoning, then we are talking about they are influenced by the voters. The voters now is to have a very big stake. They are talking about Citizens United, they are talking about climate change, they are talking about women issues, they are talking about almost every possible things, like ACA, their health care. So I think there's a very big stake there. So I think Democrat now is trying to push more emphasis on filibuster or anything postponement or anything possible. So if we can do one thing, is they have every judge, maybe they have to have a long experience from local level to the federal before they can get advanced to the Supreme Court. And then we can really select somebody, maybe you have a popular vote or something. Currently, there is a populism and election or even the Russia meddling or election. I think the whole thing is really changing people's mind. So Democrat now is trying to use their influence, whether they can get more vote from the voters.
Can I restate your comment into a question? Because
my question is,
or no, I was going to do it for you. Or do you have
my question is really, should we consider all those social issues that affect our voters and they influence a democratic decision for filibuster or any postponement?
Good. So I wanted to make a comment because this is actually something Justice Scalia was quite worried about. He gave a speech about this where he said the reason why he thought confirmation hearings had become so political was because the Supreme Court was deciding so many issues of great importance to everyday people, everyday voters. Once upon a time, Scalia said they didn't, now they are. So of course, it's natural for the political system to respond by getting involved more with confirmation hearings and who we pick for justices. It's just a natural political response. But she seemed to direct her question at you, Bill. So I would like to know your answer. For some reason, you are the subject of this
Justice
question.
Scalia said in a powerful and famous dissent that the reason why confirmation has become so fraught is the twin facts that the American people are not fools and they love democracy. They know that the Supreme Court's role has changed. That's why the stakes are so high. The court has taken on so much. Do I think that the voters have a stake in the outcome of the confirmation of justices? Of course they do. Of course they do. The only reason I think, I don't know anything about politics, I'm a law professor, but But,
Oh, really?
but as I look at what's happening politically, I think that what's happening, the reason why we're likely to see a filibuster, which in my view really is not in the Democrats' interest on this seat, is because the voters to whom the Democratic senators primarily answer, their base, are insisting on it. They're fired up. They're fired up about this, and that it will be costly to defy the base. And so the voters are having an influence on this. They really are. Now, the bigger problem is there anything we can do about the accretion of power to the Supreme Court? It's unbelievable, really, how central in how we're governed the Supreme Court is. 5 judges. Anthony Kennedy runs the country. I think that's a hard problem. I would be in favor myself immediately of amending the Constitution to provide one 18-year term. And so there are staggered vacancies, and it's not an all or nothing 30-year decision every time there's a seat. And it used to be, by the way, that people didn't have to be in their 40s and early 50s to get nominated to the Supreme Court. Now it is. Why is that? Because it matters that they stay so long. Why do they have to stay so long? Because it's a fantastic job. Wouldn't you love to run the country without any accountability? No voters to answer to? That'd be fantastic.
It's like a tenured professor.
It's even better.
Who doesn't know anything about politics?
It's even better than being a tenured professor. Because you get, well, gosh, think about it. Think about all the fanny smooching they get. It's unbelievable. So I do think that one 18-year term would be a hugely beneficial long-term small step to take.
Chris, do you want to?
No, I mean, I think it's interesting. I think that the same political powers that Bill points to that he thinks are driving Democrats to filibuster are probably also the political powers that would push Republicans to invoke the nuclear option. I think that we're sort of on this track. I would note one recent Supreme Court nominee who was not in their 40s, Chief Judge Merrick Garland, 62. And I think that sort of, and I think of him, and I don't want to make this as much as Democrats made Judge Gorsuch's hearing about Judge Garland, but when you talk about Judge Gorsuch, about being a good person and a good judge, all of those things, nobody could say a single bad thing about Judge Garland either. And so I think that
I agree completely.
there's more to it than just sort of whether you're a good guy, whether you have integrity, whether or not you have the resume experience. Because I think there's no question, right, that I don't know Judge Gorsuch. He does seem like a nice guy. There's no question that he's a person of integrity, and there's no question that he has a judicial philosophy that I think we probably would agree is in the mold of Justice Scalia. But then that is, I think, the question then. The question is then, is that a legitimate reason for Democratic senators to try to block his nomination, to oppose his nomination, whether or not that integrity to that judicial philosophy is something that Democrats view as being outside the mainstream. And I realize that outside the mainstream and results-oriented and judicial activists are all just terms we use when we don't like the outcome, but there's something to that, right? And is judicial philosophy a reasonable bounds to block somebody or oppose somebody? I think that the way these confirmations have gone, certainly over the last 4 Supreme Court nominations, has shown that it is on both sides. And I don't know if it feels like it's a bad thing, the way that the trajectory is going, but when we talk about responsiveness to the democratic institution, I don't know that it necessarily is.
I think there's one other way in which it's clear that the democratic process has impacted this whole judicial fight, and that's the fact that we have President Trump in the first place. I think if it weren't for this vacancy and when you see the major impact that had on this presidential race, you would not have seen a President Trump. This is, having exit polls that say that more than 20% of the American people said this was their #1 issue that drove them to the polls. And those voters voted decidedly for Trump. That's not even, I think that's historic, but we don't even know because no one ever polled on it before. I mean, this is something that was so off the radar for most people. And we were trying to talk, since 2015, we were trying to tell reporters, oh no, the Supreme Court's really important. Yeah, they say that every year. Oh my gosh, I think it really was this year. I think there were a lot of people for whom that was the reason they went and pulled the lever for Donald Trump. So we're seeing the fact that he's the one filling this vacancy and not Secretary Clinton as a key factor in there. And I actually do think that I agree that judicial philosophy actually is the right gauge to be looking at. I think, obviously everyone needs to be qualified, but there's a large quantity of people who would be very well qualified and nice, wonderful people. But I think if we could actually agree on a judicial philosophy that is more along the lines of Justice Scalia's, you wouldn't have the politics factoring into it. I don't, for example, know what Judge Gorsuch's position is on abortion, on marriage, on all these things. I think looking into his church tenets for all those reasons totally inappropriate as well, by the way. Because with someone with the philosophy he has, I can be confident that that's actually not what he's drawing on to make those decisions. However, when you have a philosophy where it is more of a which direction do I think the country is going? What do I think are the broad overarching values of American society? It's almost impossible not to bring one's own values into that kind of calculus. So if that is your interpretation, key to the Constitution, then I need to know what those values are. If your method of interpretation is, I want to see what the text says, I want to look at what the original public meaning it was, then your personal values aren't anywhere in the equation. And I feel like that could be the key to getting all this politics off the table. But you'd have to have everyone agree on that philosophy, which is a big, heavy lift. Maybe heavier even than the constitutional amendment that was proposed.
So I'll call on Judge Williams for the next one. Before he asks his question, I'm curious, how long was your hearing and what was the vote in the Senate on your appointment to the DC Circuit? Because it may affect your views on the confirmation process.
My hearing was about an hour. The vote of the Senate was 100 to 0. Those were the days. I'm practically 100 years old.
Clearly biased in favor.
The Senate's learned its lesson, John. The Senate has learned its lesson.
Now I have a question about the filibuster on which the panel spent the first half hour or so. When I was growing up, the filibuster involved a bunch of senators, usually really very few, usually Southern, talking on and on and on the Senate floor, their voices cracking, people bringing up buckets of water, special arrangements so they could go off for their bathroom needs and so forth. It was really, it was an interesting torture for them, of course for the country as well, but it was a torture. Then, I think it's when is it, 68? The filibuster becomes a sort of virtual filibuster. There's just a vote, and if the vote goes towards the filibuster, then we go on to the next topic. We don't have anything at all. So I really have two questions. The first is, am I not right in, that's a rhetorical, am I not right in thinking that in the old days, there was a built-in burden to filibustering, which made it of use much more rarely. And then the follow-up question is, if that's true, is there any possibility of our getting back to that era?
Gary, maybe you might take the...
Those are great points. I mean, not only had the burden on the senators, but precisely because it was such a event that is, you couldn't help but have to cover it, right? And so it generated, I mean, your point is, formally now they say, well, we don't have 60 votes, so we move on. But the absence of having the burden actually means that there's an absence of discussion of why the filibuster to begin with. And so, again, it's that institutional rule that sort of forced kind of debate and deliberation. I think you're right. You miss something when you sort of just automatically say, no, you don't have to stand here for 14 hours straight and do those things. And again, it was high-profile things when people did that. And again, they may have been right or wrong about the policy, but it actually did generate a lot of more serious debate about the issue as opposed to just passing on, well, we don't have the votes, we'll move on to something else.
Mm-hmm. I would say it's still torture. It's just now it's torture for the nominee. It's not torture for the senator. So maybe the problem is one of sort of economics and the externalities all falling on someone else. And the senators, it could cost them nothing. It costs them a vote, and they get patted on the back by their hardcore base, and then they can move on. So maybe we just need to internalize those costs again. Perhaps that would be the best. I'm not sure there's any interest on, since the senators themselves would be the ones that would have to be there reading the phone book once again. I'm not sure they're going to make those changes. We'll see.
Well, actually, I think there have been a number of Democratic senators over the past few years who've been talking about trying to change it to require a talking filibuster. I think the other thing that's fascinating and frustrating about the filibuster, to cut off a filibuster, you need 60 votes. So the people who want to end the filibuster, the burden's on them to show up. If you oppose, you actually can just leave town for a week, right? There's no burden on you. So one of the other the other proposals is, if you want to filibuster, 41 of you need to show up and vote to continue the debate, rather than putting the burden on the 60 to show up and end it. I do think there have been conversations, and I think that some senators, like Senator Merkley and Senator Udall, have continued that even with change in administration. They continued that even with the change in party in the Senate. I think it's going to take a long time to get critical mass to change those rules, but there is a growing sense of frustration, perhaps, that they don't make filibusters like they used to.
Right here.
Hi, I just had a question. I was listening to the whole.
Oh, I think you have to wait for the microphone. If I don't like your question, we're not going to give you the microphone. So. Go ahead.
Hi, sorry about that. I was wondering, I was watching the whole hearings because I'm a giant nerd, and one thing that struck me was what you mentioned about White House's comments. I think there's something he or maybe I missed there. He was saying that that Gorsuch should possibly recuse himself if the donors behind the ad supporting him, were to come before the court. If they're anonymous donors, how would he know if they came before the court?
Well, and that was Senator Whitehouse's response when Judge Gorsuch said, well, you should ask them why they support this. Like, we don't know who the donors are, but I would think that if you knew who those people were, and that they knew that they put forward $10 million to support his nomination, then that would at least create an appearance of a conflict in which Judge Gorsuch would want to at least consult the rules and consider recusing himself. So there's a question about whether or not there should be disclosure so you can get to that point. But you're right, in the meantime, without having any idea where these sources of money are, these dark money, as Senator Whitehouse calls it, then you don't have that. You don't have that. On the one hand, perhaps you don't have the question about whether or not he should recuse himself. On the other hand, you have this, I think Senator Whitehouse and others would argue, is a cloud hanging over the process.
Carrie, it's your group that's got the money, so why don't you explain yourself?
Well, I would agree with what I think what Shoshana's point was, which is if you don't know who these people are, you cannot possibly be biased in their favor in the case. So there's no need to recuse. So it seems silly to try to use that as your grounds for disclosure. Now, if you would like to change the anonymity rules as they stand, but we believe that's part of our First Amendment. This is maybe Justice Thomas's view of anonymous speech more than Justice Scalia's. I don't know, but so I think that's part of the logic there. Is it doesn't make any sort of sense to have that there. But I'll add also, I think historically you have groups taking lots of groups that do practice before the court, and we don't really file briefs. JCN doesn't really file briefs before the court, but there are groups like the ACLU. There were a lot of groups that came up and testified on both sides of the aisle. I don't think that the historical practice has been that if someone from either any of these groups either endorsed or opposed your confirmation, that you have to then recuse, because I think you'd have every Supreme Court justice recusing from all of these major organizations things. So I'm not sure. And again, this goes to our. I'm not saying that the recusal standards are such that if he had said, well, I kind of think this case is suspect, but I'll take it out as it comes. I'm not saying you'd have to recuse either. But I do think someone probably would file a recusal motion at the very least. So we'll see. But I think that's probably not even, I don't even think that would necessarily rise to a recusal issue anyway, because you have groups that are out there and saying, hey, I really do have a position on this person, and he's not gonna have to recuse himself when they file amicus briefs in the court.
So we have time for one last question. So you've been very patient there. No? You don't want to ask you just had your hand. You don't want to ask it anymore? How about, you do? Yes. Okay, so one last question, and then if anybody wants to make some additional points in wrapping up, and then we'll.
So in your opening remarks, each of you used the word mainstream, but somehow I think Mr. Kang's definition was a little bit different, so I'm going to ask you to answer last, if you don't mind. Please tell me your definition of mainstream, and then tip my hand, maybe it's not a question, where's that in the Constitution as a requirement?
So I'm recusing myself because I actually don't think I said mainstream. And also a much more important point, when we finish here, there is a reception afterwards, so there is refreshment. So maybe that's, mainstream refreshments.
That's something all Americans can agree on. So need to have drinks.
Yeah, I'll pass.
Mainstream is not in the Constitution, and I don't think actually it's a proper standard to judge a judge. I just kind of imagine sort of like a bell curve, and maybe there's some judges whose opinions are shared by very few people, and some that you got a lot of people that would agree with them. I don't think that's actually the right gauge. I'm simply, referring to it as, for example, Senator Schumer's standard that he purported to set. And I think Senator, and I have to apologize to Senator Boxer. I think I called her Barbara before Diane. I'm conflating with her for the former colleague from California. But her opening statements, or I mean, it wasn't her opening statements. It was a statement. She said, "I just want to find out if he's a conservative, if he's mainstream conservative jurist." It sounded like she was saying that actually a mainstream conservative would be okay, although I can't imagine that would be the case. But it's like this notion that he's at some extreme. He simply isn't. So if that's your justification for voting against him, I think there's no grounds for it. I just think he clearly falls within whatever one would call a mainstream. Again, that's not sufficient reason, but if that's your excuse for voting against him, try another.
Well, the Constitution doesn't address what the qualifications are for a judgeship or for being a justice. And that's entirely up to the judgment of the presidents who nominate and appoint, and the Senate that gives its advice and consent. That's it. It's entirely a political judgment. What sort of personal qualities, experience, temperament, outlook, et cetera, do we want in this office? It's that simple. I mean, and the term mainstream, I actually don't love that term at all, because it's a fairly empty term. It's like saying you're in favor of fair taxes. Who's once ever said they're for unfair taxes, right? What you want is a person of ability, industriousness, temperament, and judicial philosophy, and experience. And there's a range of people out there with those qualities, and they will have a range of views, and within that range of views, you're going to see some relative consistency depending upon the party affiliation and their approach to law. And that's, I think, all that I'm thinking about. Now, as for the politics of it, it must be that the term mainstream polls well, because you hear politicians say that all the time on both sides of the aisle. It must poll well. Extremism is bad, mainstreamism is good. It must poll well. I don't know. And what you're really looking for is, as I've said, someone who's going to be, the kind of justice whom we have. We have really distinguished judges on the Supreme Court right now, people of all these qualities. Now, if you want to talk about the politics of it, is Judge Gorsuch mainstream? For heaven's sake, he's been unanimous 97% of the time. He's had the fewest dissents from his opinions in his time on the 10th Circuit of any judge on the 10th Circuit. What are their talking points? Oh, he's affirmed by the Supreme Court a lot.
7 out of 8 times, and the 8th one was arguable, he said.
Yeah. And so that, if anything is mainstream, that's mainstream.
Yeah, I think that mainstream is clearly a political term. And I think to that extent, it's in the Constitution, to the extent that the Constitution makes this a political process. Perhaps overly political these days, but I think that's sort of where it comes from. I do think that what Senator Feinstein was saying was that she wanted to know whether or not he was a mainstream conservative, and she would vote to confirm a mainstream conservative. Right now,
I can't imagine she would. But
yeah, what do I think? Yes, I do.
Okay.
I do. And look, she is a senator that went against her party and supported Leslie Southwick for the Fifth Circuit. Right, when the overwhelming majority of the Democratic caucus did not. And so she is somebody who is willing to reach across, and I think that's the standard she set. And that is why I continue to believe that President Trump can nominate somebody who will be confirmed, right? I mean, you don't just, it's called a nuclear option for a reason. It should be more of a last resort than a first resort, right?
I think it's called the Reid rule.
The what?
the
Reid rule.
The Reid rule, sorry. It's you put a Democratic senator's name on it and call it a rule, and it means something, like the Biden rule.
Exactly.
Before.
We got a lot of them.
But I think then the challenge, though, so I do think that Senator Feinstein would confirm, and I do think that 8 Democratic senators or more would be willing to move forward with a Republican nominee who they found to be in the mainstream conservative. The challenge is that doesn't really mean much. It doesn't actually give you a great sense of what it means to be a mainstream conservative. It is an empty term. It's a term that politicians, again, just like judicial activists, right? You sort of use it when you're trying to put somebody outside of that. If you're not in the mainstream, you're an extremist, and if you're an extremist, then it's okay that I block you. And I think that, so in that way, it's sort of a cheap political term in terms of sort of defining where people are. But again, I think that you look at the academic studies, and I actually don't know how much weight to put into these academic studies, but there are enough of them out there looking at Judge Gorsuch's opinions that put him to sort of on the more conservative side than Justice Scalia, sort of perhaps even more the most conservative justice on the court if he were confirmed. And I think that that's sort of one of the markers that people think about when you talk about, Kerry talks about, is there a bell curve, what's mainstream, as we sort of try to wrap our heads around giving this term some meaning. And those sorts of things give Democratic senators pause, or maybe from some people's perspective, political excuse. But I do think that the concerns with Judge Gorsuch's record are really heartfelt. You can say they're politically expedient, but I do think like this idea, and this sort of goes back to the other idea of like, is this the right time and the right nominee for Democratic senators to block? This is the Scalia seat. It doesn't change the balance of the court. Actually, right now, the court is 4-4, right? I think a lot of Democratic senators have expressed concerns with some of the decisions that have come out of the recent balance of the court. And therefore, this is a very big place where they would want to stake their claim. And given that Judge Gorsuch is, again, in the mold of Justice Scalia, I don't think that if we talk about your judicial philosophy as being a legitimate reason to oppose a nominee, then Democratic senators should look at, all senators should look at whether or not they believe that philosophy is in the mainstream. And that's sort of where the difference is. And then the challenging part is sort of discerning how much of this is on the level and how much of this is pure politics. But I would argue that before you change the institution of the Senate irreparably, that you take another chance. See if there is somebody else that Democratic senators would be able to oppose, and then see what happens. And so, you know, I think the difference between what happened in 2013 and what's happening today in terms of the Reed rule, nuclear option, constitutional option, depending on how far you want to go back, is that Republicans filibustered Patty Millet's nomination to the DC Circuit without any regard for her record. Nobody said a single negative thing about her. That is completely different than what's happening today when Democratic senators are pointing to the concerns in Judge Gorsuch's record and his judicial philosophy. Now, maybe that's just a convenient difference for now. We can sort of talk about the politics of it, but I think that that is the way a lot of senators are looking at it to sort of square the circle. And sometimes, again, this is more about political explanation as opposed to legitimate basis. But I do think that when we talk about mainstream, because I'll actually answer the question, there's a little bit of both to it.
Can I make one quick point, John?
Very quickly.
Okay, it'll be quick, I promise. I just want to repeat a point that Kerry made in her opening remarks, which is that the standard has always been 50 votes. It's not an irreparable change, a monumental change to the Senate's practices to eliminate the filibuster for Supreme Court appointments. There's only been one justice in history who's been successfully filibustered, and that was deeply bipartisan. There's never been a requirement of 60 votes. And so, perhaps paradoxically, eliminating the filibuster will return us to where we always have been. Justice Alito, Justice Thomas, they were all in the 50s in their voting outcome, and others as well. And the filibuster really wasn't a serious prospect until now.
So I'm just left with the idea in my mind as we close that if, this might date me, but if Barry Goldwater had only said, being mainstream in the defense of liberty is no vice, he would have won the 1964 election. You should never use those bad words like extreme. Anyway, so thank me, thank me, but also join me in thanking our panel for a wonderful discussion. And join us for refreshments. And as Gary said, please join us for refreshments in the lounge next door.
Sorry.
I'm glad I'm not the only one.